Hi, my name is John Tehranian. I'm the Irwin R. Buckhalter Professor of Law at Southwestern Law School in Los Angeles, California. I'm also a founding partner of One LLP, an entertainment and intellectual property law firm in Newport Beach and Beverly Hills, California. Today, I'm not talking about either entertainment law or intellectual property law. I'm going to be doing a CLE on a topic called the history of whiteness, or everything you always wanted to know about race, but were afraid to ask. Now, you might wonder why, as an intellectual property entertainment litigator, I'm actually doing a presentation on an issue related to race and the history of whiteness. And the answer has to do a little bit with some of my research that I've done on race issues. I wrote a book several years ago in 2009, published by New York University Press, called Whitewashed. And the book examined the history of whiteness and the social construction of whiteness. And this talk is going to be building on that. We're going to be examining the legal and social construction of whiteness and tracing the dramatic transformation both in judicial and popular conceptions of race over the course of American history. Among other things, we're going to reflect on a number of curiosities in American legal history, including the early history of American slavery, which actually enabled people to be freed as slaves if they converted to Christianity. We'll be talking about Benjamin Franklin's questions about the whiteness of Swedes and Germans, if you can believe it. And we'll be discussing ethnologist Johann Friedrich Blumenbach's skull collection, which actually led to the term Caucasian and basically gave us the Caucasian race. Finally, we'll be discussing two obscure, largely forgotten Supreme Court decisions from the 1920s, decisions that are never cited today but have never been overruled. Two decisions where individuals had to litigate their whiteness before the United States Supreme Court just to become naturalized U.S. citizens. In the process, this talk is going to be challenging some of our conventional wisdom on race, and it's going to be reflecting on how and why, even in the post-Obama era, where many people have dubbed us a colorblind country, race may continue to play a significant role in our personal and professional lives. So, to give you a roadmap of what we're going to be discussing, we're going to start out discussing whiteness in historical perspective. We'll be looking at how whiteness was perceived both in the ancient world and in the colonial era, and how whiteness became a notion of race, looking at the origins of slavery and the black-white divide. We'll be then talking about Blumenbach and the individuals who basically gave a scientific notion to the concept of race, largely in the 19th century. We'll be talking about the aforementioned Blumenbach skull collection, the idea of the races of humankind, and how race and construction of race tied in with social Darwinism and imperialism in the late 19th century. We'll also be examining the history of race and new immigration into the United States. We'll be looking at whiteness as a tool of assimilation and nationhood, in particular looking at how various ethnic groups over the course of American history have been forced to press for or litigate their whiteness. Some of these groups may be surprising. They include the Irish, Germans, and Swedes, deemed by none other than Benjamin Franklin as a swarthy people who were non-white. The Italians, Greeks, and Slavs, and others. And we'll be talking about whiteness and nationhood, and specifically the naturalization trials of the 19th century and 20th century, which, as I mentioned earlier, culminated in two major Supreme Court decisions. And finally, we'll be tying this all in to why this matters today, why there is a continuing legacy of whiteness, and how race continues, for better or worse, to play a role in our personal and professional lives in the 21st century. So, without further ado, we'll begin with the first segment and talking about whiteness today. You'll see on the slide on your screen right now a photograph of Dozkhar Tsarnaev. Of course, he was one of the perpetrators of the Boston Massacre, the terrorism attacks that took place during the Boston Marathons a couple years ago. And you'll recognize his face, and you'll see above him a caption that says, "White or not." One of the more interesting things that came out of that terrible event was a debate. People started to wonder how they could categorize the ethnicity of the bombers. Some people thought they were white, other people thought they were not white. Now, you may wonder, what does it matter? Well, it's interesting. Some sociological evidence taken suggests that people's perception of the whiteness of the bombers was directly correlated with the degree to which they wanted the bombers shown mercy. So there was a study done by Noor Katelli, a professor at the Kellogg School of Management at Northwestern University, and Sarah Cotterill, a doctoral student at Harvard University. They basically took photographs of Dzhokhar Tsarnaev and asked people to evaluate his quote-unquote whiteness using a 0 through 100 scale, where he is in a particularly interesting situation because some people think he's white, other people don't think he's white. And so in a sense, he gives us a unique window to be able to study or at least get some sense of the impact of perceptions of race on people's notions of punishment. So the study found, surprisingly, that perceptions of Tsarnaev's whiteness were directly linked to how people felt about punishing him. Specifically, the study found that people who found him to be less white also were more willing to punish him severely. Conversely, those people who thought he was whiter were much more comfortable saying that he should be shown mercy. Now, of course, correlation is not causation, and there are perhaps many confounding variables that could be introduced into the study. However, the study does reflect a potentially dangerous underlying, perhaps unconscious bias, one that perhaps has been reflected in the news headlines recently with the shootings in Ferguson, the issues in Baltimore, and a variety of race-related issues and questions about police conduct involving African Americans and other minority populations that have raised to the forefront of our political debate whether perceptions of race continue to matter in the way our justice system operates. The Tsarnaev example also suggests another interesting trend, one that we'll be discussing today, which is the conflation of race and religion. Tsarnaev, of course, was a Muslim. And one of the things that was emerging in the popular discourse when he became known as the perpetrator of the terrorist attacks was the question of, wait a second, how can he be white and Muslim at the same time? This was confusing to people. This was confusing to the general American population. And again, the notion that whiteness, something that is supposedly a notion of race, and Muslimness or Islamness, something that is a notion of religion, can be conflated is an interesting one. And as we'll see, there is a long history of that. There is a long history of conflating whiteness with Christianity. And it's a trend we continue to see in the political discourse when we look at what happened with Tsarnaev. So the Tsarnaev example is one example, a small example, of how whiteness may be impacting subconsciously the way our criminal justice system is working. The next example is one that flows the opposite way, which is one that involves not discrimination against minorities, but rather the impact of remedial benefits, affirmative action policies with minorities. And what you have reproduced on your screen now is a definition of the minority business enterprise as defined by the NMSDC. NAMWOLF, which is an organization called the National Association of Minority and Women-Owned Law Firms, basically uses this definition of minority business enterprises in defining which law firms in the United States are minority and women-owned. And as many of you as practicing attorneys might know, there has been a pledge taken by many Fortune 500 companies with their in-house counsels in recent years to expand the diversity of the law firms that they retain as outside counsel. There had been some critique that they were predominantly hiring white and male attorneys and white male-owned law firms. And so NAMWOLF is cooperating with a variety of big companies to help increase diversity in the retention of outside counsel. And these companies who are using NAMWOLF are using only minority business enterprise certified entities or firms to qualify for diversity. But what's interesting is what you see when you look at their definition of what a minority-owned business is. And if you look at the section, the third paragraph, you'll see there is a listing of what groups are not considered minorities. Now, not surprisingly, individuals who find their descent in Europe are not considered minorities. But look at the remainder of the list. North Africans are not considered minorities. People from Egypt, Libya, Morocco, or Algeria. People from the Iberian Peninsula, Spain or Portugal, not considered minorities. Asia Minor region, in other words, the Middle East and the Persian Gulf, Iran, Iraq, Saudi Arabia, none of those individuals are considered minorities, which is interesting. It raises an interesting question, which is, what is our popular definition of whiteness? Well, the federal government actually, at this point, defines someone who is white as someone who finds their origin in the peoples of Europe, the Middle East, or North Africa. A very interesting definition when one contrasts it to, say, political realities these days. When people talk about a terrorist attack and they identify the perpetrator of that terrorist attack, if that person is of Middle Eastern descent, they don't say a white male bombed us. They identify that person as something else, Middle Eastern, maybe Muslim if that person was Muslim, but they're not using whiteness as the descriptor. So there is a disconnect between our definition of whiteness at law and the actual definition that occurs in practice, in reality, in society as we're living today. And that disconnect is fairly interesting because it results in some interesting results. So with that introduction, I'm going to turn into an examination of whiteness historically. Whiteness in the ancient world really meant very little. In other words, whiteness was not a race. If you said to an ancient Greek person, that person is white, they wouldn't know what you meant. And we have an example of this, or they think you'd mean something very different than race. We have an example of this with Greek historian Xenophon. This is an outtake, as you can see on the slide, of a line he had describing the Persian soldiers with whom the Greeks famously were at war for many years. He writes about the Persians: "The soldiers who saw the white skins of these folk, unused to strip for toil, soft and sleek and lazy looking, as of people who could who could only stir abroad in carriages, concluded that a war with women would scarcely be more formidable." You can see there, whiteness is just simply has a chromatic value. It's literally a description of the skin color. And the irony there is the Greek person, who we would now popularly categorize as white, is describing not himself as white, but the Persian, who would be a Middle Easterner now, as white, and suggesting the whiteness is a sign of weakness, a sign that these are people who are not used to toiling, who are lazy. And so you can see there was no direct race connotation associated with whiteness in the ancient world. Now, fast forward that to the colonial era. Of course, one of the great injustices of the colonial era, of course, was the perpetuation of slavery. As we all know, millions of Africans were forcibly brought to the United States, enslaved, and served as slaves in the American colonies. But one of the interesting facts about slavery that isn't discussed very much is the fact that originally the distinction between the Africans and the Europeans was not one that was primarily based on color. That was part of it, but it was also one based on religion. In other words, the Africans were seen as heathens, whereas the whites were seen as Christian. Now, this is important because what we end up seeing is in early American history, what could happen is, as an African American, you could actually get out of slavery by converting to Christianity, which is a fascinating fact. So you wouldn't be changing your skin color, but you would be literally changing your religious affiliation, and that was seen as a means of getting out of slavery. And so we see 2 slides up, or rather 3 slides up, we see basically that in 1690, what happened was South Carolina actually had to pass a statute in order to stop people who were African American from converting to Christianity and thereby getting out of slavery. So the loophole was closed, but it wasn't closed until 1690. So in 1690, the law was passed, 7 Stat 343, South Carolina. South Carolina's statute stated, no slave shall be free by becoming Christian. Because what was happening was slaves were getting freed by becoming Christian. Now, this notion of conflating race and religion is one that has been seen throughout American history. And of course, this ties back to the discussion we just had about Tsarnaev and the perceptions of his race, and also perceptions of race among people who are non-Christian. So first, we look back at this slide, that is the fourth slide, an early case, Reed Davis from Virginia, 1693, the first race case in the Americas that talks about punishment based on race. And in this case, there was punishment extended to someone who we would describe as white for having had sexual relations with someone we would describe as black. But note what the quotation says from the Cates Law. Hugh Davis is to be soundly whipped for abusing himself to the dishonor of God and shame of Christianity by defiling his body in lying with a Negro, which fault he is to act next Sabbath day. So the crime was not necessarily a racial one, but rather a one based on religion, the miscegenation. It was his Christianity that was what he was ashamed to, not necessarily his race that he was ashamed to. Similarly, there are biblical accounts in certain extant sects of Christianity that talk about Cain's curse. And there's this biblical account, of course, that Cain had been punished by God for murdering his brother. And some Christian sects have argued that basically people of darker skin can actually become lighter through conversion to Christianity. This is kind of the Cain's curse. And this is a belief that is widespread in certain sects of Christianity, certainly in the past. And it's a very small minority today still hold on to that belief. But nevertheless, the idea that one can change one's skin color by effectively changing one's religion and personal beliefs suggests that there is a link there between race and religion. And finally, of course, social theorists have talked about the value of changing social control mechanisms from ones based on religion to ones based on race. When one talks about religion, one notices that religions can change. When one talks about race, race is far more difficult to change. It's not impossible, but it's certainly far more difficult. And as a result, if social control is going to be exerted on a certain population, it makes more sense for the controller to exert that control based on a feature that the controlled population cannot change, namely race, not religion. And so hence we see that in the end, religion gave way to race as the demarker for slavery in the early colonial years of the United States. American sociologist Irving Goffman points out the value of focusing on immutable traits for the purposes of social control when he writes, "The most effective stigma is a visible and immutable one, as it prevents individuals from averting discrimination and differentiation by exercising control over identifying information." Now, all of this background gives way to the scientific project of creating race and giving a scientific notion to race. One of the points this talk advances is the idea that largely race is a social construct. It really doesn't have a lot of scientific credibility. However, that belief certainly is not widespread. And certainly in the 19th century in the United States, it was not widespread, as largely race began to take hold as an epistemological tool to basically govern the institution of slavery and also to deal with emerging waves of new immigrant populations that were coming into the United States in the 19th century and the 20th century. And scientific legitimacy was granted to the notion of race to basically give scientific credence to a hierarchy of race where white racial identification was at the top. Now, you have in front of you a slide of a skull collection. This is the skull collection of a very famous German ethnologist known as Johann Blumenbach. Blumenbach had a quest to basically categorize humanity into races and to give scientific legitimacy to that categorization. And so he based part of his defining criteria based on skulls, and he collected skulls. And a lot of this ended up perversely being used, for example, by the Nazis later on when they would do measurements of skulls to determine someone's Aryan composition and to make conclusions about their intelligence or their capacity for emotion or other things. Well, one might wonder why the term Caucasian. Well, the term Caucasian is a historical accident that is a direct result of Blumenbach. As this quotation tells you, one of the odd myths that have arisen in the scientific world, the Caucasian mystery invented quite innocently by Blumenbach, is the oddest. A Georgian woman's skull was the handsomest in his collection. Hence, it became his model exemplar of human skulls, from which all others must be regarded as deviations. And out of this, by some strange intellectual hocus pocus, grew up the notion that the Caucasian man is the prototypic Adamic man. In other words, he had a skull from Georgia, not Atlanta, Georgia, but Georgia, part of the former Soviet republics, right in Central Asia, actually. And ironically, it's in Central Asia. The Caucasus Mountains are right there. Georgia is in the Caucasus Mountains. Hence, he named the skull his Caucasian skull. And he determined that his favorite skull type, the one that we associate with the white race, was Caucasian. So ironically, the very term Caucasian refers to some mountains that are in Central Asia, close to the Middle East, and quite removed from Europe. And that's the term we now use as synonymous with white, because the notion of white as a skin color then became fused with the notion of Caucasian, a scientific category that had been lent credence by these ethnologists and phrenologists who had determined that skull types could tell all sorts of things about a person's traits, characteristics. Ethnologists proceeded to have a debate then over the number of distinct racial categories. And they basically defined Caucasian as individuals of European descent and Middle Eastern descent and North African descent because of the similarities in the skull shapes. They also identified at least two other races, as they called them. And those races had various names like Ethiopian or Negroid, as they called it back in the 19th century. Mongoloid was another identified race, and some people added a fourth race, Malay. But those were largely defined as the races of humanity. And the Caucasian category became synonymous with whiteness, and it enjoyed uniform adoption in the major scientific treatises of the 19th century and early 20th century as basically this scientific notion that there was such a thing as race, that it was defined by and associated with certain personal characteristics. And of course, all of this was used to legitimate imperialism, the conquest of the darker people in the world, third world countries, of course, being taken over by both European and American colonial interests. And the theories of race provided a basis to provide division in humanity. They basically gave rationale to why we would give some people rights and other people's no rights, or we'd give some people more rights than others. Caucasian became conflated with whiteness, and it became a tool of imperialism used to scientifically rationalize and legitimate the distinction between conquerors and the conquered, between the colonialist and its subject, between the center and the periphery, and of course tied in with social Darwinism. Now, all during this time, the United States faced a crisis in terms of new immigrant groups. As you're all familiar, this is a nation built on immigrants, and the immigrant flow began to become particularly steep in the mid-19th century and continued through the late 19th century and early 20th century, with a series of crises in Europe that led to large groups of immigrants coming to the United States, immigrant groups that were previously not in the United States. The immigrant groups largely in the United States that had settled the United States at the founding were largely of Anglo-Saxon descent. But in the 1840s, there was, of course, the Irish potato famine, which led to a wave of Irish immigrants seeking refuge in the United States for a better life. And this resulted in what Yale professor Matthew Fry Jacobson has called a crisis of whiteness. all of a sudden, a whole bunch of immigrant groups were entering the United States who previously were not part of the United States. And as a result, there were questions as to whether these individuals were actually white. As you can see from this political cartoon here, or not even political cartoon, but sort of emblem of looking at contrasting what was called the Anglo-Saxon race versus the Irish race. You see a sketch of Florence Nightingale, and then by contrast, you see a sketch of someone called Bridget McBruiser, what is a stereotyped Irish person. If you look, you can see the phenotypical features given to that Irish person, which look awfully like racist sketches one might see of African Americans later on in the 20th century. Basically, as new groups from Europe came into the United States, people questioned their whiteness and said they were not white. And the Irish were the first among the groups to face this kind of discrimination. The Irish faced persistent and pervasive discrimination. You see here an ad reproduced from an old newspaper, basically looking for someone to be hired. And the job posting says, "No Irish need apply." The Irish suffered pervasive discrimination. In Boston, employers frequently refused to hire individuals of Irish descent. And Irish people were deemed the blacks of Europe. There's a 1906 reported Texas murder case that it signifies the vast discrimination the Irish faced. In the case, H.L. Mays, a black male, stood accused of murdering a quote-unquote white boy in his late teens. What had happened was, while working in the yards of the Southern Pacific Railroad Company, the victim had apparently taunted Mays by calling him Irish. Now, the fact that being called Irish was viewed as an insult to a black man at the time, early 20th century, demonstrates the extent of the prejudice that was given to people of Irish descent, a state of affairs that is rather unfamiliar to us today. Now, all of this might seem quite ridiculous, but as further evidence of the ridiculousness, consider Ben Franklin, one of the founding fathers, and his views on whiteness. In views that are probably shocking to people today, he believed that whiteness was largely defined to Anglo-Saxons, and his view was shared by many of the founders, and that was a pervasive view in the early framing years of the American Republic. Here we have two quotes from Benjamin Franklin discussing the non-whiteness of people of German or Swedish stock. He writes, "Why should Pennsylvania, founded by the English, become a colony of aliens who will shortly be so numerous as to Germanize us instead of our anglifying them, and will never adopt our language or customs any more than they acquire our complexion?" To him, the Germans were clearly a dark people, unlike the white of the Anglo-Saxon. Further writing, "The number of purely white people in the world is proportionally very small. All Africa is black or tawny, Asia chiefly tawny, America, exclusive of the newcomers, wholly so, and in Europe, the Spaniards, Italians, French, Russians, and Swedes are generally of what we call a swarthy complexion, as are the Germans also, the Saxons only excepted, who with the English make the principal body of white people on the face of the earth. White male in 1790 meant not Swedish, not German, not Italian, not Greek, certainly not Slavic or Russian, not even French maybe. It meant someone of Anglo-Saxon stock." And so, as the years passed on, we saw discrimination against vast numbers of groups on racial grounds, claiming that basically they were not white. The Italians, for example, long had to fight for recognition of their whiteness. They faced significant discrimination throughout the United States. And a court case from 1922 involving allegations of an alleged white woman sleeping with a black man, again a miscegenation case, suggests the extent of the perceptions of Italians. In Rollins v. State, the Alabama Court of Appeals actually overturned the conviction of a woman named Edith LeBeau for engaging in sexual relations with a black man. Edith LeBeau was accused of being a white woman, and in fact, her conviction was overturned because it was determined she was Sicilian. And because she was Sicilian, she was viewed as non-white, so she had not committed the crime of miscegenation. as the quote from the Alabama Court of Appeals goes, there was no competent evidence to show that the woman in question, Edith LeBeau, was a white woman, or that she did not have Negro blood in her veins and was not a descendant of the Negro. Why? Because she was Sicilian. Example of racial perceptions of Italians who had come to the United States. You can see a couple of these political cartoons that were highly racist against Italians. Regarding the Italian population, you see a nuisance to pedestrians, sleeping apartments, afternoon pleasant diversions. Shows a way to dispose of them, shows them throwing them into the ocean. The way to arrest them shows cops beating them. As two American historians have written, Italians were one of the most despised groups in America. Old stock Americans called them wops, dagos, and guineas, and referred to them as the Chinese of Europe, and just as bad as the Negroes. And in fact, one of the interesting things is in the Old South, Italian school kids were oftentimes put in the segregated classrooms with the black students. They were deemed non-white. And right here in California, Italians were surprisingly, as late as the 1950s, segregated as well. So for example, in public pools in San Bernardino County, there were public pools that had a white days, and a day for Latinos. Italians were told and forced to swim in the day for Latinos, so they were considered Latino, not white. So a further example of the discrimination they faced, of course, obviously in addition to what the Latinos faced and other groups like African Americans faced. Greeks and Slavs faced similar discrimination. Here we have a Nebraska case involving the beating of a Greek man named Pappas during some race riots. And you have the line, in a notorious criminal case that made it to the Nebraska Supreme Court, a group of Anglos waylaid a Greek man named Pappas before brutally robbing, beating, and forcibly sodomizing him. One of the perpetrators revealed the underlying racial animus that was goading the attack, declaring, quote, "You blank Greeks ain't gonna run this town. The white people are gonna run this town." Similarly, a handbill from a campaign in Birmingham, Alabama, 1920, basically discussing the vote, said, they have disqualified the Negro, an American citizen, from voting in the white primary. The Greek and Syrian should also be disqualified. I don't want their vote. If I can't be elected by white men, I don't want the office. And again, a statement from Senator F.M. Simmons in North Carolina talking about these new immigrant groups like the Greeks and the Slavs and Syrians. The new immigrants are nothing more than the degenerate progeny of the Asiatic hordes which centuries ago overran the shores of the Mediterranean, the spawn of the Phoenician curse. So we can see significant discrimination against a variety of groups that today we unquestionably deem as white, groups such as the Italians, Slavs, Greeks, and Irish. Now, one might wonder, what was the significance of all this? Well, the significance was dramatic, and we see the significance of whiteness in an example I'm going to be given, which is the naturalization race trials. Basically, most people don't know this, but until 1952 in the United States, you had to be either white or black to become a naturalized U.S. citizen. Again, until 1952, you had to be either white or black to become a U.S. citizen. You couldn't be naturalized any other way. So, how did this come to be? Well, in the early days of the Republic, Congress, after passing the Constitution, ratifying the Constitution, limited naturalization to anyone who was a, quote, free white person. Shortly after the Civil War, in a wave of progressivism during Reconstruction, Congress amended the Naturalization Act, and they said, or black person. But the result was not changed until 1952, which meant if you were neither white nor black, you could not become a U.S. citizen. And of course, not many people were going to petition to be declared black by law, because that came with a whole host of other race discrimination. So the result is, basically, from the post-Civil War era till 1952, you had a series of cases that occurred throughout the United States where individuals from new immigrant groups systematically petitioned the United States government to be declared white by law. The U.S. basically had race trials. Now, one might wonder why this was so significant, why they wanted to be declared white by law, other than, of course, the social perks due to pervasive discrimination that might come from being deemed white by law. There were significant economic and political benefits. Of course, Naturalization is required to become a citizen, right? And as a citizen, you get the full privileges of the republic. Today, that means voting and some other privileges. But back in the day, it actually meant a lot more. Citizenship was fundamental not just to exercise political rights, but also to exercise fundamental social and economic rights. Now, just as a slight digression, oddly enough, back in the day, as a citizen, you didn't have to be a citizen to vote. In fact, there's nothing in the Constitution that requires citizenship to be a voting member of the American polity. In fact, until the late 19th century, in many states, non-citizens regularly voted. It wasn't until sort of a xenophobic fervor after World War I that was significantly restricted, but still to this day, in certain counties in cities in Maryland and in Cambridge, Massachusetts, non-citizens can in fact vote. However, the right to vote was significant. Is a significant part of naturalization, but generally, but even more so, there were economic rights tied in with naturalization. So you see here from Cheryl Harris, a professor who has written extensively on whiteness and its impact on social and economic relationships. She writes, in the early years of the country, it was not the concept of a race alone that operated to oppress blacks and Indians. Rather, it was the interaction between conceptions of race and property that played a critical role in establishing and maintaining racial and economic subordination. What property? Well, the most important form of property, especially for generating wealth, is commonly in the United States known as real property. And non-citizens in many states could not own property. So many laws were passed restraining non-naturalized immigrants from exercising fundamental economic rights. In California, for example, there was something called the Alien Land Law. The Alien Land Law, passed in 1920, prevented non-citizens from owning property in the state of California. And if one thinks about that, that is a significant means towards the American dream, which all of these new immigrant groups, to the extent that they were deemed non-white, could not participate in at all. Other economic rights came with citizenship as well. In order to become a lawyer in many states, you had to be a citizen. To get something as simple as a fishing license in many states, you had to be a citizen. And so your exercise of professional rights and your ability to generate income, pass that on to your family in terms of wealth, was all constrained dramatically by whether you were deemed white or not by law. And so these naturalization trials had huge stakes. Two of these naturalization trials ended up before the United States Supreme Court. These are cases that are largely ignored and forgotten today, but they are a fascinating window into the dynamics of race construction and how the Supreme Court basically was telling us, even at that time, that race was a social construct implicitly through the way that it analyzed the issue of race. The first case involved Ozawa, an individual of Japanese-American descent, who petitioned to become naturalized. In 1922, the Supreme Court heard his case, and he had support from many individuals, including famous Wigmore, the man most famously known for the treatise Wigmore on Evidence. He embraced Japanese whiteness on the grounds that, quote, the Japanese have, quote, greater affinities with us in culture and progress and facility of social amalgamation than they have with any Asiatic people. Notice how Wigmore is arguing the race of the Japanese. It has nothing to do with biology. It has nothing to do with their skin color. It has to do with culture, their ability for progress, their facility for social amalgamation. Nevertheless, the Supreme Court rejected Ozawa's petition. And in a follow-up case, United States v. Thin similarly rejected the petition for whiteness by an individual of Indian descent from the Indian subcontinent. The Indian man argued literally that, hey, I'm from the Indian subcontinent. We are the original stock of the Aryan race to the extent that exists, and therefore I am technically Caucasian, and that is true certainly for many North Indians. And so therefore on anthropological grounds and ethnological grounds, he was deemed white. However, the Supreme Court said no. The common knowledge test is going to dominate. We're going to look at what an average person on the street would deem you to be, and those people would not deem you to be white. Similarly, although Ozawa had skin that was white, in fact, as white as most white people, if not whiter than many people who by that point had been categorized as white. The court said, no, we're going with common knowledge, and a person who is Japanese is not white, according to the court. Now, the result of these decisions was significant. And as I've argued in some research papers and articles I've written, basically the Supreme Court set up a test for race that was then applied by the lower courts. The test was a performance test. Litigants were asked to perform whiteness. And race was determined largely on a dramaturgical basis. In other words, litigants had to prove their whiteness by showing how well they performed whiteness. What does that mean? It has nothing to do with biology. It has nothing to do with skin color. Courts instead looked at litigants and they said, what kind of character do you have? What religion are you? If you're Christian, that's white. If you're non-Christian, that's non-white. How wealthy are you? If you're wealthy, that's white. If you're not wealthy, that's not white. Your class orientation, the language you speak, your ability to intermarry and hang out with other people who are known to be white. All of those were put on trial. And so you have a series of cases where individuals who were Parsi, who were Arab, who were Armenian, had to fight and litigate for their whiteness. And the results of those cases are actually quite fascinating because they give us a window to just how biology has very little to do with race and how much performance has to do with notions of race. Two cases involving Armenians give an example of that. In re Halajian and United States v. Kartosian, Armenians were narrowly considered white. On what grounds? Chiefly several that dealt with performance. Number one, it was pointed out repeatedly that the Armenians were a Christian people, in fact, the first Christian nation, and as a result must, of course, be white. Again, the conflation of race with religion. Secondly, their ability to intermarry, to interact with certain known white populations, their language abilities, their class orientation, and their character was put on trial and was deemed to be white. Because they were deemed to be of good character, they were deemed to be able to intermarry, and as a result, receive the benefits of whiteness. The cases involving Arabs are quite interesting as well, because sometimes Arabs were deemed white, sometimes they weren't deemed white. We have a couple of cases there, Inri Hassan and ex parte Mohrez. When the Arabs were deemed white, the courts focused on performative criteria. They talked about how the Arabs are often Christian. And in fact, the majority of the United States Middle Eastern Arab population is in fact Christian. There was also an emphasis on the mathematical, philosophical, and scientific learning of the Arab people and how that was given to the Greeks, and the Greeks basically gave us Western civilization. And so the court would talk about their book learning and their cultural affinities with Europe. And as a result, they were deemed white. When the courts deemed Arabs non-white, what would they focus on? They would focus on Islam. And they would say these are clearly a non-white people because they're not Christian. We haven't moved too far from that today. So performance lay at the heart of the determination of whiteness, especially where it was a close call. Character traits, religious practices, class orientation, language, ability to intermarry, and other factors that have no inherent meaning in terms of race as a biological fact, to the extent that even exists, were what determined race. Now, all of this discussion about race may make one think, okay, that's all in the past. Yeah, the days of segregation are done. We don't discriminate as overtly anymore. And we've had a remarkable change in the last half century in our country, where many race-based practices that were deeply pernicious have been outlawed and made illegal. And we've certainly transformed dramatically. But there's a tendency in popular discourse, both in the law and culturally, to relegate history to the realm of antiquity. We've historicized racism. Consider a few popular opinion polls. In 2011, a Gallup poll found that 78% of white Americans feel that blacks are now treated equally with whites. Only 39% of blacks, however, agree. 38% of white Americans believe that racism is a significant problem, whereas 65% believe there is little difference between the economic and social conditions of whites and blacks in our society. Now, no matter what you might think about that and what you might think about whether racism is still alive or not, or the social conditions of white or blacks, the idea that the economic conditions of blacks or white is not different in our country, and there's little difference in our country, is, as a factual matter, absolutely untrue. Unequivocally untrue. One can debate the reasons for that or the causes for that, but it is absolutely untrue, as I'll show you in the census data, which I'll be citing near the end of my talk. And in fact, Michael Norton and Samuel Summers have found that on average now, white Americans view anti-white bias as more prevalent in our country than anti-black bias. So to the extent that the average white American sees racism as a problem, they point to racism against white people. Now, in the law, we've seen the embrace of color blindness and the notion that racism is dead reflected in a number of ways. Famously, Arizona, through HB 2281 a few years ago, outlawed ethnic studies programs in public schools on the theory that racism is passé. They allowed teachers to teach historical racism, but they said that it was no longer permissible to allow anything that might advocate ethnic solidarity or have programs that are designed primarily for pupils of a particular ethnic group. So the Latin studies programs that had been adopted throughout the public school system in Arizona now became illegal. The Supreme Court has reflected this trend towards color blindness. Famously, Justice Scalia in Adirondack Construction wrote, "In the eyes of the government, we are just one race. It is American." And Justice Roberts, more recently in striking the remedial policies of the Voting Rights Act, talked about how much the country has changed and how the need for the Voting Rights Act, which maybe had been present 40 years ago, is no longer reflected because the racism of the past has been vanquished. He wrote, "The country has changed, and the Voting Rights Act, based on 40-year-old facts having no logical relationship to the present day, must be stricken." And that was in the Shelby County case. However, race seems to have a funny way of continuing to percolate in the headlines. Sort of absurdly, in 2002, in September, there were panicked headlines around the world claiming that blondes, and therefore the white race, were headed towards extinction. But more seriously, in 2000, the voters of Alabama eliminated a provision in their state constitution. It was still in their state constitution that dictated the legislature shall never pass any law to authorize or legalize any marriage between any white person and a Negro. By the way, it said Negro still in 2000. Let me add to that, though, what happened on the other side. 60% voted for that. 40% of people in Alabama in the year 2000 wanted a constitutional provision to remain in their state constitution outlawing the marriage of whites and blacks. 40%. It's a stunning number in what is purportedly now a race-blind country. Whiteness continues to be prevalent unconsciously. The power of whiteness continues to be prevalent unconsciously. One can look at an American Economic Review study in 2006 that acknowledged the huge significance between pigmentation and socioeconomic achievement. The study found that even among blacks, skin color had a substantial impact on wages. With all things being equal, lighter-skinned black men significantly out-earned their medium and darker-skinned counterparts. So the economic data continues to suggest significance to whiteness. This applied also to immigrant groups. A study by a professor at Vanderbilt in the economics department found that average light-skinned immigrants out-earned dark-skinned immigrants by approximately 10%, even when controlling for race, country of origin, English ability, education, occupation. The detriment, quote-unquote, of dark complexion is so significant that it sometimes wipes out any benefits accrued from educational attainment. In other words, even of people from the same country with similar English abilities, educations, occupations, when you just control for all that and look only at the skin color difference, it makes a difference in their economic output. Joni Hirsch, the Vanderbilt professor I alluded to, wrote, "I thought that once we controlled for race and nationality, the difference would go away. But even with people from the same country, the same race, skin color really matters." And an interesting study that was done a couple of years ago looked at subconscious discrimination by looking at referee foul calls in the NBA, split-second decisions that are made not with overt discrimination in mind, but are subconscious. And the study found that to a significant level, white referees called fouls at a far greater rate on black players than against white players in the NBA. Again, not overt discrimination, but a sign that perhaps there is still significant discrimination that abounds. And certainly the recent headlines that we've seen in the news in recent months has seemed to confirm that at the minimum, we still have racial issues that we must contend with as a society. We alluded to the recent race riots, the actions by police with respect to the African American community have all raised serious questions about the nature of race-based policing and the American criminal justice system. And so we still see race play out. We also have an interesting divergence that's occurred in American jurisprudence. On one hand, we see race-based programs, especially remedial ones like affirmative action, really close to the brink of extinction, at least legally speaking. In recent years, the Supreme Court has significantly ratcheted back the legality of affirmative action. The Seattle School District case outlawed it at the high school level, and there is a current case pending before the Supreme Court right now, the Fisher case, that could end affirmative action entirely at the collegiate level, which has been narrowly upheld only on diversity grounds. So at once we have affirmative action on the brink, where the courts have told us that we live in a colorblind world and we have a colorblind constitution, and that the government cannot and should not be making racial distinctions, whether they are doing it for supposedly good-natured purposes or not. Now that's all well and good, but there's a whole series of case law that seems to point the other way as far as the government still being able to account for race. Case law that is never addressed when dealing with affirmative action. So, for example, we have case law from the Supreme Court that basically continues to allow the use of race in criminal enforcement. In fact, there have been efforts at the congressional level for several years to stop and make racial profiling absolutely illegal as a matter of law. Those efforts have failed. No law has been passed that actually outlaws racial profiling. Of course, one might say, well, you know, that might be a useful practice. But if that's a useful practice, one has to ask then, why are we pretending then that the government is colorblind? Because if the government can account for race when engaging in criminal enforcement, if the government can account for race, as the courts have repeatedly held, when deciding whether someone is unsafe for transportation on an airplane because they may look Middle Eastern, if the government can account for race when engaging in immigration sweeps, even away from the border, because someone looks Latino, well, then the government is allowed to account for race. And if that's the case, then we don't have a fully race-blind constitution, and that has to be reconciled with the affirmative action jurisprudence. So race continues to play a role in our jurisprudence, and there is an interesting mix in the way that there have been attacks on the use of race in a remedial sense, which is increasingly almost extinct at the affirmative action level, and the use of race, which has continued to be permitted for profiling, for criminal enforcement, for determining who might be a threat to national security, and for also immigration law purposes. And those two things have not been fully reconciled in the discourse. Now, as a result, race continues to have relevance. And although one day we may eventually render the category of whiteness meaningless, the power of whiteness still pervades our social, economic, and political lives. Now, I'm going to leave you with one final graph, which to me, I think, is one of the most stunning pieces of data that's come out in recent years. What you can see here is a graph that draws on data from the United States Census. And typically when people talk about racial or gender differences and discrimination, they often look at rates of income that people make. So we all famously know that women continue to face discrimination in the workplace, earning 80 cents on the dollar for every dollar that men make. However, studies don't as often look at wealth. And wealth is tremendously important because income is just what you have coming in. Wealth is the accumulation of not just your money that you've made during your career, but also inheritance. It is a reflection of privilege that comes from prior generations as well. And when one looks at the wealth difference in the United States based on race, the results are stunning. The average white family in the United States in 2010 has a median wealth of $110,000. The average black family, $4,995, average. That is a 22-to-1 difference between the average black family and the average white family. Now, you can say what you want about the reasons for that. There can be lots of debate about why there is such a huge, stunning difference between the wealth of black families and the wealth of white families. But going back to the Gallup poll data we talked about earlier, one cannot say with a straight face that the economic conditions of blacks and whites in our country are equal. They're not. There may be reasons for it, but they're not equal. And the data is similarly terrible for Hispanics and even, quote unquote, the model minority, Asians. The average wealth of a Hispanic family, $7,400. The average wealth of an Asian family, $69,000. So huge, dramatic difference still in wealth between white families and non-white families. Now, one might at least take some solace in the idea that, hey, you know what, things are getting better. Things are improving. And largely in our country, that's absolutely true. Racism has certainly improved. Our racial conditions have certainly improved in recent years. However, this data actually suggests otherwise. You might say, well, at least this is probably better than what happened in 2000 or 1990 or 1980. But you'd be wrong. In fact, since the census started taking account of this data in the 1960s, early 70s, what's happened is this number is at its all-time worst in 2010. In other words, the disparity between blacks and whites in family wealth was at a peak in 2010, worse than it was in 1970, 1980, 1990, and 2000. That's not to say the sky is falling and that everything is getting worse, but on this measure, we're actually doing worse than we did 40 years ago. And this measure alone suggests that there is continued work to be done. So with that, I'm going to just wrap it up and summarize what we've talked about. So in summary, what we've basically seen is through our historical examination of whiteness, as well as our examination of the continuing relevance of whiteness, we've seen how race largely is both a legal and social construct. And this legal and social construct has led to differing definitions of race, differing definitions of whiteness through the course of American history. Race has changed in order to meet certain political, social, economic exigencies. And with that knowledge in hand, I believe that that can help individuals look to how they perceive race today, decouple it from the scientific or biological fact that the way it's been taught in the past, and better be equipped to deal with issues of race going forward. Although we've come a long way in our country and in terms of our American legal justice system, in terms of bettering the way we deal with race, there is still work to be done. And we have a promising future, but nevertheless, we need to keep an eye on the issue of race rather than dismissing it as something or mere vestige of the past. This has been John Tehranian. I am the Irwin R. Buckhalter Professor of Law at Southwestern Law School in Los Angeles. And I'm also a founding partner of One LLP, an intellectual property and entertainment firm with offices in Beverly Hills and Newport Beach. My main practice area is in the entertainment and intellectual property litigation area, but I've also written on issues of the law and race, including a book called Whitewash that came out in 2009 and upon which some of the content of this speech is based.